Hello, everybody, and thank you for joining us today. So for those of you that require CLE credits, please note that Arizona, California, Connecticut, New Jersey, New York, and Ohio are approved or pending for 1 hour of a general technology or cybersecurity credit. A code will be announced at the end of the session. I'm Kyle Fath, a partner at Squire Patton Boggs in our Los Angeles office. We are a global full-service law firm with over 40 offices in 20 plus countries. I'm based in Los Angeles. I'm part of our data privacy, cybersecurity, and digital assets group. I have a broad privacy and cybersecurity and AI practice with a wide range of clients in a variety of industries with a substantial specialty in advertising technology. Also spent a lot of time on biometrics, AI, children's privacy, and other privacy and product counseling issues. I will pass it on to our other panelists today, Beth Jacobs, to introduce herself.
Hi, Beth Jacobs. I'm Managing Counsel of Global Privacy at Little Caesars. I oversee the privacy program and team at Little Caesars, so both the legal and compliance aspects of privacy compliance.
I am Sasha Kiosse. I'm an associate at Squire Patton Boggs in the New York office. I'm also in the data privacy, cybersecurity, and digital assets group. And I'll kick off this presentation. Here's our agenda. So first, we'll be discussing the general legal background regarding data protection assessments. We'll go over data protection assessment content requirements, as well as other requirements that are typically found in the state laws. And then we'll move on to a discussion with Beth Jacobs on the practical implementation of these requirements. So first, for the legal background. Originally, just 3 years ago, there were only a few state privacy laws. We started off with 5 states with comprehensive consumer privacy laws. And just a few years later, 20 states have enacted comprehensive privacy laws. All of the laws follow a very similar formula of obligations for data controllers and rights for consumers, although there are important distinctions between the laws. Most of these comprehensive privacy laws require data protection assessments. These are essentially risk assessments that a controller is required to conduct if a high-risk processing activity is being undertaken. The requirements under the state laws for these assessments are inspired by the European Union's GDPR and the guidance provided by the European Data Protection Board as to the GDPR. The table that you see on this slide shows all 20 state laws. Notably, Utah and Iowa are the only states without data protection assessment requirements. California doesn't quite have data protection assessment requirements yet, but has released draft regulations that do require data protection assessments, but these regulations have not been enacted yet, and we'll discuss the draft regulations in a little bit more detail later on. So the comprehensive privacy laws that you saw on the previous slide are not the only US privacy laws that require data protection assessments. For example, there's been a trend of states recently passing laws specific to children's privacy. Some of these laws are called age-appropriate design code acts, and these laws in particular are being litigated on First Amendment grounds right now, and their future is not clear. But these laws also require risk assessments for businesses before the business provides an online service, product, or feature that is likely to be accessed by minors, and before the online service, product, or feature is actually provided to the public. Connecticut also, as you see here, has added provisions related to minors to its comprehensive privacy law, including by requiring additional assessment questions for controllers that offer an online service, product, or feature again. And this applies when the controller actually knows or willfully disregards that the consumers are minors. So it's not enough to just not know, but actively willfully disregards is also a factor here. Another example of other laws that require assessments are new AI laws, artificial intelligence laws. Colorado has recently passed an AI Act, which requires risk assessments when a high-risk AI system is being deployed. The assessment requires discussion of the intended use cases of the high-risk AI system, the kinds of data that is used as inputs for the system, details about metrics used to evaluate the system, and a description of any measures and safeguards taken to protect the data as well. Part of the California draft regulations I mentioned also is regulating AI and automated decision-making, and additional assessment considerations are required when such systems are in place. Then there's also a category of laws that don't specifically require assessments, but practically it would be helpful and maybe even necessary to conduct an assessment anyway. For example, the Children's Online Privacy Protection Act and Illinois Biometric Information Privacy Act require certain notice and consent practices. Assessments would allow controllers to keep track of their data processing activities and ensure that these obligations are actually complied with. Another example, the Washington My Health, My Data Act requires companies to establish, implement, and maintain administrative, technical, and physical data security practices that satisfy the reasonable standard of care within the industry. The documentation of processing practices in this case also helps to ensure requirements are met. So while these are not specific assessment requirements, it is practically necessary in some cases to still conduct and document the data processing practices and procedures to meet these other laws and obligations. So when are assessments typically required under the comprehensive state privacy laws? Assessments are definitely required when a company is processing sensitive data, selling personal data, engaging in targeted advertising, and engaging in high-risk profiling. High-risk profiling is profiling in furtherance of decisions with legal or similarly significant effects. Now, that is the actual phrase that is used in the law. And basically what this phrase means is these are decisions that may potentially have a big impact on a consumer's life and may include decisions affecting the provision or denial of housing, education opportunities, insurance, criminal justice, healthcare, and essential services, among others. Most of the laws also leave this open in terms of the high-risk processing activities, meaning that they provide for other high-risk processing activities as well, which means that even if a controller is not selling personal data, processing sensitive data, or engaging in targeted advertising or profiling, it may still be required to conduct and document an assessment if there's another potentially high-risk processing activity being engaged in. The California draft regulations also provide for assessments when there is monitoring of a publicly accessible area, monitoring of students or employees, and training artificial intelligence or automated decision-making technology. So these are some examples of additional practices that may be considered high risk in the other states, even if the other states don't explicitly provide for such processing activities. Now, although there's 18 state laws that require assessments, many of these laws have subtly distinct requirements, and in some cases, very different requirements. The laws luckily provide that a single assessment can be used for multiple state laws as long as all the requirements are met, and can also satisfy several related processing activities. So it's not necessary that a company has to conduct and document a separate risk assessment for each individual processing activity. Oftentimes you can merge comparable processing activities into one assessment and also use that one assessment to achieve the requirements of all of the state laws, as long as the individual requirements under the laws are met as well. So now I'll just briefly talk about data protection assessment requirements. Like I said, the state privacy laws mostly don't have many content requirements or inquiries for risk assessments, but they require basic information about the data processing as well as a risk-benefit analysis. So typically, controllers are required to provide a summary of the processing activity, a description of the personal data involved, the context and purpose of processing, the risks and benefits of the activity, including any measures or safeguards that are taken or will be taken to mitigate those risks, and the risk-benefit analysis. The result of the risk assessment should be that the benefits outweigh the risks of the processing after the appropriate safeguards are implemented. If that is not the case, the processing activity should not be undertaken under the state laws. Often, the external and internal actors involved in the processing activity should also be discussed within the risk assessments and may be helpful in accurately and fully conducting the assessment. Some of the states have more stringent requirements and more specific requirements as to data processing assessments. For example, Colorado requires 12 specific questions to be answered, with an additional 12 if a controller is engaging in high-risk profiling. I won't go over all of the inquiries, but just to give a few examples of the requirements, the following are some of those. So specific measures and safeguards must be addressed, which is true for the other laws as well. But the Colorado Privacy Act also requires the discussion about specific safeguards, including the use of de-identified data, measures taken to ensure that consumers are given access to all of their consumer rights under the law, and measures taken to address all consent requirements. So this mostly applies to sensitive data processing. Additionally, the law requires information about recipients of personal data, including names or the categories of recipients. So, for example, third parties or processors, as well as the purposes for which the data will be provided to those recipients and how the controller evaluates each type of recipient for compliance. So how does the controller actually look into each of the potential data recipients, and how does it determine that the data can safely be provided to those recipients? Next, there's the law also provides for descriptions of trainings, policies, or practices within the organization to mitigate risks. And then for profiling, some of the inquiries are specifics about the data used and the decisions made, benefits of automated processing over manual processing or human-led processing, explanation of the training data and logic used in the profiling system, information about any third-party software used, and how the system is evaluated for fairness and disparate impact, so considering any risks of discrimination. The California draft regulations also would require additional inquiries. A few examples include the approximate number of consumers whose personal information the business plans to process. That is a bit of a tough one. No other states require that. Then also the technology used in the processing, the outputs of automated decision-making and how they will be used, and a requirement that the assessment be presented and summarized to the board of directors or governing body. Some other requirements, all of the states require the inclusion of relevant internal actors and external parties to address the data protection risks. So this specifically is for Colorado, but as I mentioned before, the states also do require some discussion of this. Additionally, this isn't specifically mentioned as a risk assessment requirement, but within the state privacy laws, processors are required to provide necessary information to controllers to enable them to accurately conduct assessments. Some states also require retention of completed data protection assessments and updating requirements. So for example, in Oregon, you must retain the assessment for at least 5 years after the completion of the data processing activity. In California, it's 5 years. This is the proposed draft regulation. And in Colorado, at least 3 years, and review annually for profiling. There's also something that's not written on the slide, which is that if there's a material change, then of course you have to update the assessment as well.
Yeah, and I'll jump in with one last point on that last slide, Sasha. I think to underscore the the point on processors, Obviously this is a lot of work internally for data controllers to gather all the information required to carry out the assessments from, both internal and external stakeholders. But I think it also, presents a lot of like legal and business risk to processors as well. And processors are going to have to, if they have not already, prepare to provide information that's requested by their controller, customers, for example, like platforms and SaaS vendors and things like that. One thing I've encountered quite a bit in, negotiating contracts and even like in an assessment process with clients who are controllers requesting information from processors or negotiating agreements, like this provision that Sasha, or this obligation that Sasha mentioned, is, it kind of runs contractually to processors through required controller processor terms. Very often what I'll see is, processors will say, okay, with respect to like this and like information in respect of audits, they'll say, okay, we'll give you, for example, like our most recent SOC 2 report. I think that sort of providing that sort of information in respect of a privacy assessment is non-responsive. There certainly are aspects with respect to assessments that do touch on security, but I think that sort of, and that has been my experience quite a bit. Processors and vendors asserting, hey, here's security documentation for assessments and in respect of audits, and that's not good enough. And so I think companies that are processors are going to have to really prepare to have information on hand that they can provide readily, really to adhere to their contractual obligations, as well as to prevent business disruption when, say, like a really big customer comes to them asking for this information.
Yeah, and another requirement is about disclosure of assessments as well. So all of the states require disclosure of completed assessments upon request from the state regulator, which is typically the state attorney general, with a few exceptions. The California draft regulations have more stringent requirements. The regulations provide that the businesses will have to submit certain documents within 24 months of the effective date of the regulations, and then annually after that. These include certification of compliance, basically stating that the business has complied with all requirements, and also designating a qualified individual within the organization to sign off. Additionally, a business will be required to submit risk assessments to the agency in abridged form, the agency being the California Privacy Protection Agency, which is the regulator in California. And this abridged assessment can be submitted on a form provided by the agency. This abridged form will have to identify the processing activities, the categories of personal information, an explanation of the purpose of processing, and why the negative impacts do not outweigh the benefits. And then a full unabridged risk assessment has to be provided upon request by the agency, although a business may also provide a link to the full assessment in its submission of the abridged assessment. This will be available on a public webpage, although trade secrets and names may be redacted. The states generally provide that disclosure of assessments to the state regulator do not make the assessments open to the public and do not negate attorney-client privilege or work product protection. California's draft regulations don't specifically provide this assurance, although the California effective California law has general carve-outs on trade secrets and privilege. Before we go into the discussion with Beth, I want to note again that the California draft regulations are not currently finalized, and changes may be made and are expected as well. It's not totally clear when the regulations will be finalized and go into effect. The board is set to consider a vote to move the regulation package forward to public comments on November 8th. If this happens, and meetings in the past have been postponed, but if this happens, the public comment period is 45 days, followed by any modifications made in response to the public comments. And then there's an additional 15-day comment period. Then the final rulemaking package is submitted and reviewed for 30 business days before the regulations would go into effect. So the earliest that the regulations would be effective is sometime in February or March, considering that there are no modifications and everything goes as planned. So I would be prepared for some leeway with that. And I think it's possible that the regulations will go into effect later than that. So next we can go into the discussion with Beth Jacobs from Little Caesars. I'll move this slide. Oh, sorry.
Yeah, we did add some just slides on resources. One last point, I think, on the attorney-client privilege. I think one other thing that I think companies need to consider is, like, based on the requirements, filling them out dutifully, they will, in some respects, be almost like a tell-all expose about some of your most, sensitive, maybe most intrusive data processing practices. And so it seems like it's paramount to ensure that carrying out assessments is done pursuant to attorney-client privilege. So that means, like, having it be done at the direction of the legal department, limiting the dissemination of the assessments to keep them tight to the vest. Don't widely distribute them to folks other than a limited group, keeping them close to the vest, and otherwise putting in practices to prevent that from happening. We have some clients who have decided to create, like, similar to like the abridged versions you're gonna have to create and submit, potentially California, creating, abridged versions that, business issues only, and then legal sort of advice and conclusions, and like a, broader version that is subject to attorney-client privilege. But just food for thought, think about attorney-client privilege when you're, carrying out assessments. Otherwise, this sort of document assessment, results of it may be discoverable in some, sort of litigation later on. And like I mentioned, it's, pretty much a tell-all expose about a lot of different activities that you might be carrying out from a data processing perspective. So wanted to throw that in there. So I think a couple of different resources on carrying out assessments we wanted to mention. We have developed an assessment toolkit that has various sub tools to it. One is a state law comparison chart, kind of laying out the various requirements state by state that Sasha went through in a very detailed manner. Guidance checklist, but I think most importantly, full assessment templates to help you work through all of the requirements, answer all of those questions that are, like, example, like in Colorado, very detailed, going through question by question with, guidance and practice notes and figuring out how to do it. And also supplemental templates specific to like different use cases like AI, automated decision-making technology, children and minors, consumer health data and biometrics. And so we have this toolkit available for a fixed fee. If anybody's interested, please feel free to reach out. And then I think also something worth mentioning is we have partnerships with consulting firms who have basically loaded our assessment templates into OneTrust. And so it, to the extent your company uses OneTrust, or you could decide to engage OneTrust and the consultants at our direction. We've set it up in a way to implement it in a way that you can do it quickly and efficiently with your business, like using the OneTrust platform. I think another, we want to put a plug in for the Interactive Advertising Bureau. The IAB has developed a diligence program, very much specific to a lot of like digital advertising use cases. But the IAB, the platform, we've put a link there for people to look into. Certainly something else to consider as well. The IAB has put in a ton of work. Some folks from our firm, myself, and then Alan Friel have been involved in helping put that diligence platform together. And so that's something worth checking out as well. But please, if you want information on either one of these, please feel free to reach out. I think we're ready to talk to Beth, but maybe just one last plug before we do that. Put some QR codes up. Our AI Law and Policy Hub, just our various websites and platforms we have for thought leadership, and Privacy World is our privacy blog. Yeah, maybe we start the discussion with Beth here.
Let's just quickly mention this code, data 1022 for CLE. So please, if you're looking for CLE, please remember this code.
And we can flash that back at the end if people didn't catch it.
Yep.
And so, yeah, so Beth, thank you for being here with us today and sitting through the first part of the presentation. So I think the first question that I would have is, how should a company go about deciding whether an assessment is required in the first place?
Sure. And just my disclaimer, these are my personal thoughts, not necessarily the thoughts of my organization, but just I can sort of talk generally based on my experience. I always think that it's really helpful to have the conversation, whether it's a shortened sort of intake form, whether it's an inquiry that comes into the privacy department or the legal department with just, hey, this is a new project that's getting started. But to get eyes on it to the extent that you can, it does not have to be a full-blown assessment, but at least understand the who, what, where, when of what's happening with a particular project to then determine, does it raise to the level of needing to have that heightened degree of assessment. I'm a big advocate that the only people who can make a determination as to whether or not there is a privacy issue or there's a privacy concerns related to something is sort of whoever's in charge of privacy. It shouldn't be left to the business. And so I'm a big proponent of just being involved in as many discussions as you can, creating the process where privacy becomes part of the assessment of new initiatives, to just be able to hear what's going on. And then having that staged assessment where you get sort of those initial intake questions to figure out what's going on and then determine, does it have a privacy issue that does need that additional level of scrutiny based on the answers to that sort of intake that you've done.
Yeah, so it sounds like, yeah, you've got like a certain process in place and like, maybe to stick with like, a particular vendor sort of use case. And so what are some strategies you've implemented to integrate this like assessment or like pre-assessment process at like the initial stages of a project, like taking a new vendor in or engaging in a new activity?
Yeah. So I think you always have to look for the existing processes that are in place within an organization. The worst thing you can do is create additional friction because it makes you even less popular when you're slowing down projects. So looking for those opportunities to, I guess, where projects are sort of being evaluated anyways. An RFP process. Do you have certain requirements around when an RFP is required? It's for everything, it's for some things, but can you insert privacy questions into the RFP process to make sure that stuff's getting evaluated and hopefully you're getting the responses from the RFP as well? Do you have any sort of project approval committees or capital expenditure committees where these big sort of projects, they need to go through some level of an IT steering committee, any sort of group that is responsible for approving different types of projects, inserting privacy questions or assessment questions into those existing processes? I think it's really important to be built in, not bolted on. I think that's also a really good way to get some of those initial questions answered, to even figure out, does privacy need to be involved in the long run? But it is a bit of privacy by design, right? I mean, being involved in the conversations from idea to implementation and making sure that you can be there as a guidepost throughout And again, finding those processes that exist, I think is much harder to stand up a wholly independent process than to integrate or become another step in an existing process. So if you do cybersecurity assessments, if you do third-party risk assessments, privacy being a part of that assessment process so that you get your questions in there and you're able to start your assessment process earlier rather than later. So you're involved to help, again, steer where it's going rather than it's the check the box at the end and all of a sudden you potentially have to be the roadblock to say, whoa, 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 you can't do it the way that you designed it. Figure out where those stage gates exist earlier and then insert yourself to the extent that you can in those processes.
Yeah, absolutely. I think that makes a lot of sense. And I think, getting in early and understanding like what the data flows are, what the potential vendor is doing, or what the new use case entails, you're able to help, you're able to work with the business team and maybe, be a yield sign and say, okay, well, maybe we think about these things a little differently rather than, at the end where they've designed something or figured out a certain product they're working with a certain vendor. And then you have to, instead of being a yield sign, be a stop sign. And so it sounds like get involved early, get involved often, wrap it into an existing process.
Yeah. Especially if it's an approval process, because then if you're part of the approval process and things can't get greenlit until you've signed off on something, that often helps as well. Because then it's even less of a choice that they come to you. They've got to sort of be involved because they're not going to get, whatever approval that they need unless you've signed off on it and said, yes, we're good to go on this.
Yeah, that's a good morsel, like baking into like some sort of approval process. So yeah, I guess like back to the, like assessment sort of process itself and deciding like whether assessments are required. What about certain things that like fall into a gray area? Like, hey, it's not clear here whether an assessment is necessary. What do you do in that sort of situation?
Yeah, I mean, I think to the extent that you have the resources to be able to do it, I'm a big fan of documentation. I'd rather over document than under document. And so I do think that, if it is a gray area, again, to the extent you have the resourcing to be able to do it, I don't think it hurts to do a more in-depth assessment just so that you have it and that it's documented. I think too, Sasha went through, here are the types of activities that require a DPA or a DPIA, and I think that those are like the baseline sometimes, and that there's opportunities to look at other types of jurisdictions that maybe have a broader set of requirements for when you have to do them. Especially, if you're a global company, you're probably looking at them anyways, or hopefully you're looking at them anyways. But also looking too at just what are the other types of things that could create risk. So processing large volumes of personal information. There are certain systems that even though you might not be using it for one of those high risk activities that were mentioned, it just by itself, because of what it has in it, might be considered a risky tool that you have. I think that's often helpful too, is to just determine based on like a risk scale. So there's the stuff we have to assess, and then there's the other stuff where it might be, hey, it doesn't require one, but the type of information that's in here or the volume of information is something that we want to look at. I do think that it's a bit of a risk calculus that's individual to every company. Not every company they're not all operating in the same decision or jurisdictions. They don't all have the same risk tolerance. So part of it is also going to be understanding sort of what the company's risk position is when it comes to these types of things. Do you have any bright line rules as an organization? Maybe it's a rule, we're just not going to use biometrics. So you're always going to assess anything that has biometrics or assess it differently. Those types of things. And it is going to be a little bit context dependent for the company, but I think it's the things where you look at it and say, do we feel that there's a potential degree of risk here that requires the heightened degree of assessment so that we can document it and say, hey, we put controls in to try and reduce the risk, even if technically we weren't required to do an assessment for it.
Yeah, I mean, that's all good stuff. And I think kind of what I heard was, certainly a lot of it is like, resource dependent. I think like certain companies are a little bit leaner on the privacy front, and that sort of company may just be forced to make a decision. Like if something is in a gray area or something we know assessment's not required, we don't have the manpower to do that. Other companies, like your company, for example, that has quite the staff on the privacy side and good resources. Sounds like you're able to make those decisions to err on the side of like, let's make an assessment. So I think it's like a company by company sort of determination. Also just like risk tolerance, certainly, yeah, there are many companies, like biometrics is a good example. Some companies have just decided we're not going to be doing that. And the vast majority of circumstances might make exceptions, but yeah, it's a kind of a company by company resource sort of determination with respect to like, maybe we don't need to do an assessment, but depends on our risk tolerance and, just our, the bodies we have to help work on this stuff. So yeah, makes a lot of sense. And so, what we heard a lot from, during Sasha's part of the session was like, we need to get information from, both, like internal, external stakeholders. And so when you're carrying out an assessment, what internal stakeholders are typically involved, and how do you suggest, getting buy-in from them? Are you like taking them cookies, or,
So I think it's really important that your business folks understand what it is they're doing and buying. I think that especially if they're outside of the IT space, it can be really easy to just hear a lot of cool features from a vendor and not really understand what that means. How does it work on the back end? Where is the data going? What data is being collected? That type of a thing. And so I think that it's very important for business partners to understand how their tool works. So they, I think, are always, they should be involved in the assessment process. I don't think it's something that should be just handed off to the vendor to answer the questions, and the business, remains no more informed about what it is that they're doing, because the vendors asked all the questions. And part of the reason I think it's so important is because if features change in the future, if they didn't complete the assessment, they might not necessarily know that how those impact your assessment. They might not know that the assessment has to be updated because they were never involved in sort of asking those questions from the beginning. So the business partner is hugely critical. I do think vendors play a role in it. So the business isn't always going to be able to answer every question, but they should have a general sense of how it works. And then for those more technical questions, or for the ones where the business might not be quite clear on it, going back to the vendor directly and saying, hey, I need you to explain this to me. Can you provide me with a diagram that shows the data flows and how this is all working? Can you answer some of these more technical questions to get the direct insight from them? I also think it's really important to partner with your other sort of assurance functions that you have that are looking at some of these things. So cybersecurity, third-party risk management, these other groups that are also doing assessments, because they might ask a different question, or something that's similar to what you're asking. They might have gotten a slightly different answer because maybe they asked someone different at the company, at the vendor, at which point it's really important to reconcile those two things. So if your assessment tells you one thing and cybersecurity tells them something different, we've got to figure out where the disconnect is. And so there's, I think, a lot of parties that are involved in the process, some to different degrees of involvement, but there's a lot of stakeholders that you need to sort of be checking in with to make sure that everyone is understanding how this works and how it fits into the broader ecosystem.
Yeah. It's I think what you said about collaborating with other internal stakeholders who might be carrying out like similar assessments. Maybe like the marketing people that you're working with aren't as sophisticated quite yet on all the data related issues. Sometimes we hear from them like, oh, there's no PII involved. But then, then you kind of educate them a bit, and then but then you talk to like a security person and you figure out, oh, maybe there's like a, direct like API pool or some sort of integration from a technology perspective that there is a lot of data flowing back and forth, and it is certainly personal information, personal data under the state laws. So yeah, that makes a lot of sense. So like, you mentioned like getting on calls with like vendors, that sort of thing. Are there any other sources of information from that, or any other ways or like sources of information like that you can get useful information for assessments from third
Yeah.
parties?
Yeah, I mean, I think it does depend a little bit on the third party that you're working with. Some of the ones that are really privacy conscious and privacy forward, they do make things publicly available on their websites. I would say they're probably few and far between, but they do exist. Similar to like a lot of the tech companies will have resources for security or IT that are on their websites. They will also include sections on privacy where you can get some additional information. You can read their privacy policies. I don't always find them that helpful because they're usually specific to the website that you're visiting, where they're trying to sell you the product, and not specific to the product itself. But sometimes there's, they're linked or there's a kernel in there that's helpful. Again, and then when you have those conversations, going straight to the vendor and asking and saying, hey, what do you have that's documented around your privacy controls? I know it has all of these features and you tell me that I can control these features and toggle things on and off, but can you give me a list of what those things are to help me make a determination based on our risk appetite? What do we want to turn on and off? Again, I don't think every vendor always has that readily available, but I do also think that it's a sort of bonus points in their favor when they do, because it at least demonstrates a commitment to privacy. And so they're all, I think, legitimate places to look and questions to ask as you go through the process.
Yeah, and you raise a good point about like product sort of specific stuff. I think my experience often has been, a lot of vendors will at least have like publicly available like documentation that is a mix of software code that is sort of unintelligible to a non-software engineer, but also like a mix of various things like, hey, here's how to pass us like an opt-out signal, that sort of thing, privacy related documentation, and often it's on a product by product basis. So I think it's like a mix of having to like work with your internal teams to figure out, okay, here's like this dump of information that's actually, yeah, it seems very helpful. Which of these products are we using, so we can figure out, okay, which part of the documentation and other things apply, and how do we need to assess, how do we need to wrap this into our assessment process? So let's talk a little bit about I guess in terms of like quantifying potential risks and impacts that you identify in an assessment. It's like, how do you go about doing that? And, are there particular like frameworks or methodologies that you think work well?
So I do think, again, it is a little bit company specific based on risk tolerance. And I think it does come back a bit to what are the things as an organization that give us pause, the things that we give that heightened degree of scrutiny to. I think there's always the things that are going to be at that higher level of risk that you really need to dig into, things like social security numbers, race, ethnicity, the sensitive types of information. Those are always areas where the question is this necessary? Do we need it, right? I mean, it's the whole data minimization concept. And if the answer is no, then, or maybe we need some of them and not all of them, it's like, okay, well, let's get rid of the ones we don't, right? I mean, that's like an easy way for us to minimize risk here is let's stop or not collect through this process these things that, we don't need. And then for the other ones, are there controls in place to minimize the risk? Is it a hashed social security number? Is it only the last four? What are the things that we can do to minimize the risks associated with these? And so I think that it's helpful to sort of understand the ideal world. So this is how the business wants it to work, right? If they could do whatever they wanted and it worked exactly the way they wanted, this is how it would look. And oftentimes the things like, yeah, we're collecting social security and all of this sensitive information is merely a function of the fact that that's what the vendor told them the tool could do. And they didn't really know to think about, well, do we really need it? Do we need it in a clear text form, that type of a thing? And so understanding what they want it to look like or how it is currently intended to function, to then go in and to say, okay, here are the risks that I see. Let's understand what controls we can put in place to minimize the risk. And then if you can minimize the risk to a point that sort of fits within your organizational risk tolerance, great. If there's stuff in there that can't be mitigated, or it can't be mitigated to an acceptable risk tolerance level, I think then it is a conversation, or I guess, sort of you as the legal department or privacy, it is a bit of a conversation around, are we permitted to do it? And if the answer is no, that was pretty easy to say, okay, well, we can't mitigate the risk, and because we can't mitigate the risk, we're now no longer permitted to do this. If it's in that gray area, or if it's yeah, you're still permitted to do it, it's just a risky thing to do, I do think there's a little bit of it going back to the business and being like, you need to understand the risk universe that this is creating and what the potential fallout from these risks could be. And if you're okay moving forward with that for these, these things that can't be mitigated, then you own the risk, and it's your decision, and you can move forward with it. But again, I mean, that's dependent on it not being illegal. But as long as it's sort of something that is permissible and it's set up that it's still permissible, if the business is comfortable with the risk, I think it ends up being a business decision.
Yeah, no, that's been my experience working with clients on like quantifying risks and impacts. And sometimes it truly comes down to like, like this, implementing this feature, or like requiring consent, or like putting up a cookie banner on this, on our website, or adding this single line to like a disclosure. We've done testing, and it is going to result in like X, X fewer, number of people staying on our website, and that will lead to the reduction in our revenue of like Y percentage. And so it often, like comes down to like, yeah, can, and like a lot of stuff you talked about, like, can we even mitigate this risk in any respect? I think a lot of times certain respects, like particularly like in the, like some digital advertising related, consumer facing data collection, a lot of times it does come down to like true just numbers of, all right, here are the risks if we do not adopt this certain aspect of compliance. And here's the potential penalties if we do not do that. But here's also the potential business risk of doing so. And very often it's like a business call by business stakeholders of, okay, like here's the potential risk. The probability of that risk is unclear, though, with 20 state laws in place, the FTC focus on things, maybe the probability of that risk is higher. And in view of the business impact, we're going to move forward without implementing this feature. I think that's I think a lot of the conversations I've had with a lot of clients of, decisions on, implementing certain, quantifying risks and impacts, and then deciding whether and to what extent to mitigate them. So, sometimes it truly does, my experience, like also come down to like just numbers and business decisions about what the business impact will be, balancing that with like the privacy impact and the risk. Maybe switching gears a bit, Sasha alluded to like AI related assessments. How are you approaching assessments for like projects involving AI or machine learning? Are there specific risks or issues or models you're dealing with, or are you just similar process that you do with regular privacy issues?
Yeah, so I mean, again, I think it comes back to the way just approaching the risk assessments generally is trying not to create additional friction on the business. So integrating into existing processes, existing assessments to the extent possible. There might be some tools that are just, because there are tools that exist now that have AI features that are different from it is just an AI tool. And so when you get to that, it's just an AI tool, maybe that does require a different type of assessment or a secondary assessment because of the type of tool that it is. But for some of the things where it's an AI feature that's built into an existing vendor or a new vendor that you're looking at, a new tool, maybe it's sufficient that you can get the questions into just your regular assessment process. I also think that sort of smart assessments are really helpful, where you have the logic that's built in, where depending on answers to questions, you can get into more in-depth answers. So if a tool doesn't have AI, or it doesn't even collect personal information, you might ask an assessment question and get 3 questions in and be like, hey, there's not a privacy issue here. And we don't ask the rest of the questions, because you can identify the fact that there's nothing to really be concerned about, or not the way that you would on other things. But you could get into a tool, and because you've built a smart assessment, and they start answering the questions that you're asking, and you can have follow-up questions sort of built in to determine, can we address our AI assessment as part of this? And these questions that we've now asked because of the information that you've given us, does that give us enough, or does it at least tell us we need to do a much deeper dive into the AI assessment process to really dig into this particular tool? And then looking at the laws that are out there to help determine sort of what other things that we want to look at, right? So does it impact things like financial decisions, or education, or employment, or those types of things, where it's, the risk is there. It's specifically what the law is looking at addressing, in Colorado, and then looking sort of at the EU, and what is the EU doing, and what do they want you to assess, and being able to determine based on that, the degree to which you have to dive deeper into it. But to the extent that it can be part of the existing process, I think is really important, because once you start to train people that, hey, you've got to come to us, they don't want to have to come to you for 4 different things. They want to be like, I did my privacy assessment. I came and talked to you. I got all of the questions answered, and we're good. I think so, to the extent that you can prevent having to go through multiple assessments is really important.
Yeah, absolutely. And I think, one thought I've had, looking at the forthcoming proposed CCPA regs is, the automated decision-making technology, which includes artificial intelligence in its definition. I think it's truly going to be a game changer. I think in particular, in relation to there's a new opt-out for profiling for behavioral advertising, other provisions related to profiling, and in particular, companies with California employees. It's going to be a real game changer, especially and companies, AI applications. I think in the HR context, are some of what I've encountered the most with clients, and so a lot of that's going to be really consequential. And I think the assessment related provisions, we'll see where they land when the regulations are final. But I think to the extent that they land anywhere near where they currently are, which seems likely, there's going to be a lot of work for companies to be doing on the assessment front with respect to AI, automated decision-making technologies, with respect to HR data, particularly for those with California employees. But yeah, certainly what you said of wrapping it into the current processes, and probably with respect to HR, beating the drum even more to say, hey, this stuff is coming, probably going to require a deeper dive than we're currently doing. But having a process in place, I think will go a long way to help you tack that on to what you might currently have in place.
And I think too, not everyone understands how broad the definition of AI actually is under these laws. And so they're thinking just generative AI a lot of times, sort of these big AI tools. And so if you tell people, hey, you have to do an AI assessment if you're using AI, they're not always going to think that what they're doing, because it's automated decision-making, is AI. So to not have it as a separate assessment is really helpful, because they just sort of they get shoehorned into the existing process anyways. They don't have to decide if it's AI. Your tool is built to determine that, and you can ask the questions at that point.
Yeah, actually, someone just came in with a very topical question, I think, to that. It's so do you have any tips on how to assist respondents in responding to assessments? Some responses may be clarification, but do you rely on anything like policies or training to ensure that you get responsive answers to assessment questions?
Yeah, so I think it's a combination of all of those. FAQ documents can be really helpful. So what is a definition of personal information? If you're not asking people to pick certain specific types of personal information in their questions, you just want to know if it has personal information, you should give them a definition of what do you actually mean by personal information. So FAQ documents are really helpful. Maybe not job aids, but like an assessment aid where it actually goes through like, what do we mean by these different questions? We've gotten on the phone with people and we've done it together, especially the first time someone's doing it, so that they can understand what do we mean, especially if they're not in an area that's really familiar with privacy. What I have found that over time is that you end up starting to work with the same people over and over again in different departments, because not everyone in a particular department is responsible for purchasing technology or making some of these decisions. And so you do start to find sort of who are your frequent flyers. And as you spend time with them, as they get familiar with doing the assessments, they do start producing better responses quicker. Because it's just something that they're used to. But I don't want to say hand-holding, because it's really not hand-holding. It's an education process, especially when people go through it the first time, is to just sit there and make sure that you can work with them, reviewing the questions and then following up with people too, if there's not enough information in it. So, especially in the beginning, it is a bit labor intensive as people get up to speed on how to do it.
Yeah, all good stuff. We've got 2 minutes. Any sort of last words, takeaways for the audience?
I would say it's iterative. So the first version of your assessment process is not going to look the same in 6 months. I think as you're sort of out in the wild and trying to get this done, you'll find the things that work and don't work, and the parts of the assessment that work and don't work, and just sort of having that mindset of we're constantly evolving it to adapt to the environment in which we're trying to work. It's like a never-ending process, unfortunately. But it does mean then that your assessment does become more responsive to sort of your organization and how it operates.
Yeah, that's great. I think my closing message would be, I think there are, I think that just the current approach to privacy compliance for most companies, with respect to US at least, is very much addressing like public facing obligations, like draft, privacy policies, especially post Sephora, like making sure you're addressing the sale that results from certain cookies. Now companies are sort of forced into addressing cookies further through SIPA lawsuits. I think once regulators start asking companies to pony up their assessments, that's going to cause companies to really scramble to put these together in 30 days. I think it's probably honestly impossible. And so it's going to be a game changer for companies and how they deal with privacy. It have to be from the bottom up, from the, privacy by design will really have to be a thing. But so yeah, I think the message is companies that haven't gotten started on these yet, get started now. I think I think the code for the CLE, just repeat that one more time. It was data 1022. Data 1022. Thank you everybody for attending today. Thank you, Beth, so much for joining us and spitting some wisdom. And thank you, Sasha, for laying the groundwork with all the requirements.